Jersey, and Missouri. I am also a former teacher. I spent about 10 years working for the New York City Department of Education. I entered the teaching profession as a teaching fellow and worked as a special education teacher. So today's presentation, quick figures for teachers who need estate planning. I have my contact information here. I do hope you'll jot it down and perhaps we'll have the opportunity to speak in the future. I've got my logo there. I've also included a member organization that I participate with, Lawyers with Purpose. The reason I want you to be clear that even though I'm a solo attorney, I do affiliate with other attorneys. In fact, we're in contact, gosh, usually 5 days a week to discuss different client needs and different plans that are available. So I'm a solo, but I have a big network of support. Most people who contact me want to know, can I protect my stuff? Can I protect it from taxes, from long-term care, from family? And how do I do that? The other things are a little more basic. For example, what is a power of attorney, a living will, and a healthcare proxy? What's the difference and what do I need? What is a trust and what's the difference between a revocable trust and an irrevocable trust? Now, we're all teachers here. Surely you can see the irrevocable means that it can't be undone, it cannot be taken back. But I'm going to show you that by properly setting up your irrevocable trust, you're going to put everything in a nice, neat box. And actually, you could change the trustee, the person who has the authority to go into that box and access your stuff and provide for you and for the people you care about. How can I avoid probate? Many people come to me and they say, Paula, I just want to avoid probate. They may have heard a horror story. They may have lived through a horror story. Can I or should I give my stuff to my kids? Now, you might think, well, of course I want to give my stuff to my kids. I'm going to differentiate between a direct gift and a gift that allows your kids to have benefit of your stuff, but it's not a direct gift to them. And why would you want to do that? If I give my stuff away, will it take 60 months for it to be safe? That's a question that is based in Medicaid policy. You may have heard that there is a look back of 60 months in most states. Definitely, it's new in New York that it's 60 months. And so, is my stuff safe? Can I qualify for Medicaid if I have a pension or other income? That is largely the question that motivates me to speak before you today. I can't tell you how many teachers believe that because we have a pension, I have a pension as a New York City teacher, because we have a pension, we won't qualify for Medicaid. That is absolute myth. It is 100% incorrect. And I can show you the basics in this presentation of how we can use those Medicaid laws to your benefit. You can keep your pension and you can have access to full protections of Medicaid. Do I have to go broke to qualify for Medicaid? That's another big myth. No, you don't. Are my IRAs safe? Do I need a special plan for my IRAs? We're going to talk about when some people will say to me, well, I don't really need a will because I've got designated beneficiaries on my accounts. In other words, if I go down, all of my stuff, in my case, all of my stuff goes to my daughter. Well, I still need a trust in order to make sure that everything is 100% safe. Also, 1 year after she inherits my IRAs, she no longer has the same protections as a retirement account gets. It just becomes a regular account because she's not a retiree. How can I plan for my disabled beneficiaries? You might say, well, wait a second, Paula, I don't have any disabled beneficiaries. You may not have any disabled beneficiaries now, but suppose I leave stuff to my daughter. She's 31 now. Suppose she has a stroke in her 50s. Well, I want something in my plan of how I'm leaving assets to her that will still allow her to access vital things like disability or Medicaid, even though she has this nest egg that I'm leaving to her. So she would become special needs. She would become a disabled beneficiary, just not right upon my death. And I want to make sure that my plan accommodates that. So, anything else that you want to know, you've got my contact information. I hope you'll reach out. The main thing that people come to me and ask is, am I all set? I need to be all set. We start that process by identifying your current plan. I'll tell you that you already have a plan, even if you've not sat down to do a will, a trust, or anything else. I'll show you how the government has a plan for you already. We'll explore what it takes to protect you while you're alive and your stuff. Don't try to learn everything. Just anchor to the stories that I'm going to go through, and we'll find out what's missing so that we'll define, are you all set? That's a picture of me and my daughter taken about 4 or 5 years ago. We were both a little bit younger. That was pre-COVID, so we both look a little bit different. Um, I mentioned that the government already has a plan for you, even if you have not begun the process of writing your will. The government has rules. The government has a set of rules for you during your lifetime. For example, right now, who has authority over your stuff? Well, you're vertical. You're standing up, and so you have authority over your stuff. You have the power of attorney. You can sign your own checks. You can enter into contracts. You can invest your money as you want. Um, the government also provides that you can complete a healthcare proxy or living will so that you can determine end of life questions. So if I'm incapacitated, I want 14 days on a breathing tube, and then I want that turned off, stuff like that. If you don't have these things, don't worry, because again, the government has a plan. The government has a process called legal guardianship. The government conducts a full-blown trial. They bring in government attorneys. The hospital probably brings in attorneys. Your family might want to bring in attorneys. There's a full-blown trial. There are 2 doctors required by statute who will testify as to your incapacity, and they will then determine if somebody else can have legal guardianship of you. So don't worry if you don't have a plan, because the government's got your back. After death, the government rules still prevail. If you have a last will and testament, it will determine the executor, the beneficiaries, and the government has a process for sorting through those documents. So hear me out. Even if you've written your last will, that doesn't mean that on the famous day when everybody gathers at the attorney's office and they read the will, very dramatic on television, and then of course in television, the long lost heir then moves into the mansion, and some people are mad, and the person who moves into the mansion is thrilled. That's not really how it works. I'm sorry to tell you. The government has a process. Each state mandates by statute how long probate will last. In New York, probate must last for 7 months. So during that 7-month period, you're gone. You don't have control of your stuff. Your heirs don't have control of it. The government does. The court does. The judge does, or the trustee that is appointed. There can be delays in that. Let's see. What else do I need to tell you? The cost. So think about it. So many people come to me and say, I want a basic will. And what they really are saying is, I don't want to spend a lot of money on attorneys. I get you. I totally understand. I've been there. In fact, I still try to save money whenever I need to refer to an attorney. AARP estimates that between 5 to 20% of the total value of your estate will go to the cost of filing that probate application. In New York, it happens to be $1,250. That's $1,250 that must be paid before the court will even begin to process your paperwork. And so that means that somebody in your family must reach into their pockets and get that money and pay that money. Then it goes on, because the court is going to want an accounting. So ka-ching, you're going to hire a CPA, or your family's going to hire a CPA to go through all of your accounts and be able to present to the court a certified document that says a certified audit of your holdings. Real estate must be appraised. All of that adds up. So let's just take a teacher who has put $200,000 away, either in TDA, an annuity, or IRAs, or maybe they've saved, they've got their Robinhood account going and they've been putting money in there. They've got some cryptos on the side they've been putting in there. By the way, the cryptos are going to have to be evaluated, so get a specialist who knows cryptocurrency. Let's say a teacher's estate has 200,000. That 5%, which is very low by AARP's estimate, your family is going to be out $8,000 upon your death to assess what's there. So my message to you is a basic will is really just sending that bill of planning, of estate planning, down the road to the next generation. Somebody's going to have to pay it. Maybe you're trying to not pay it. I totally understand that, but somebody in your family will have to pay that money at some point. I want to distinguish between documents, which are things like the will, the power of attorney, the healthcare proxy, versus planning. A plan is going to be something that takes care of not only when you die, but suppose you've retired and you have a stroke and you need long-term care. Maybe you need a nurse to come in a couple of days a week. Maybe you need to go to a rehab facility to relearn how to speak or how to walk. Maybe you've just had a bad case of the flu, and upon discharge from the hospital, the doctor sends you to rehab for 6 weeks. Who's going to pay for that? How do you plan for that now? So the fault that I see with a lot of estate planning is that people are planning it when they're vertical, and then they plan for when they're horizontal, in other words, when they're dead, but there's very little plan for in between and the gradations of, well, suppose you're bedridden. Well, you're not dead, but you do have needs. Again, the government has a plan. We've talked about guardianship. We've talked about probate. Some people want to know about taxes. Most teachers, now there are some exceptions, but most teachers are not going to have a tax issue, at least as the rules are laid out right now. The Trump tax reforms allowed that up to $11.58 million of your estate can pass to the next generation tax-free. Most teachers don't have 11.58 million. New York's taxes, the estate tax is still at the old rate, which is 5.85 million. We do expect those numbers to change, so stay tuned, and you'll hear me talk about the importance of not only making a plan, but revisiting a plan, because stuff like taxation will change with each administration, and as you know, there's a big discussion right now on taxing the wealthy. Your plan allows for where you are now, where you want to be in 5 years, 10 years. Maybe you want to travel now and you want to have access to that money, but you also want to have some of it segregated in case you do get sick, or some of it segregated and tucked away to pass along to your children or to your spouse. What happens to your stuff if you become incapacitated, and who's managing it? And what happens to your stuff when you die? Some people say, it's very, very simple, Paula. I'm leaving it all to my spouse. Well, let's talk about that. A direct gift, like I, Paula Collins, leave all of my stuff to my spouse. Currently, I don't have a spouse, so it makes it easy for me. But let's say I had a spouse. Your direct gift might be so generous, and your spouse will be so in love with you upon getting that huge check or those deposits to their accounts. But you know what? If that spouse has an illness or a stroke, or needs, as they age, they might need nursing care, or they might just need housekeeping, which can be provided through Medicaid. But if you've left a nice big nest egg for them, they won't qualify for that. Your direct gift is also not protected from creditors or from predators. In other words, those robocalls that say, hello, I'm the prince from so-and-so, please send me your contact information. And then suddenly the elderly spouse, who has been set up very nicely by you, is scammed. So there's no protection against that. Your direct gift might be used to pay for that your current spouse's new spouse when they go in a nursing home. Well, gosh, maybe you would want that, but maybe you wouldn't. Maybe you would want your nest egg to go to help your spouse and then to go to your children that you have together. And then that new spouse, the new marriage, they would have to find other resources to take care of themselves. And what about your kids? If you give everything to your spouse, what about your kids? It could all get spent. An irrevocable trust with proper assignment of duties to a trustee whom you choose and can change gives maximum protection to your spouse, and it helps provide for your long-term care needs while you're alive. The other thing that people say is, well, forget the spouse. She's got her own retirement. She's got her own pension. She can come up with money. I'm leaving it all to my kids. Well, guess what? Your direct gift to your kids might disqualify a college age child or your college age grandchild from financial aid. Suppose they're a sophomore in college and you go down, boom, you're out, one and done. You have that fatal heart attack, and suddenly that sophomore in the parent who has a sophomore child in college loses all their financial aid because guess what? They just came into some money. Uh, wouldn't that be a blow? And wouldn't that be too bad? Because wouldn't you rather them continue to get that financial aid and use the money that you've left to them to put a down payment on a house or to open a business when they graduate from college? We'll go on. Your direct gift might cause them to lose special needs benefits. I mentioned that before. Suppose if I leave stuff to my adult child, I want them, if they have a stroke or if they have a medical need, we're in the age of COVID right now. If they have to recover from COVID, I want them to have access to all of the benefits that are available and to have this money that I've left to them sort of walled off and tucked away into some kind of fund that won't come under consideration and therefore disqualify them for benefits. Your direct gift is not protected from the creditors that I mentioned before. Even spending, upon death, people change. I'm kind of harking back to the spouse, but also to the kids. People change. The person who is so frugal right now, when you're gone, they might be grieving and might turn to shopping. A shopping addiction is a very real thing. And suddenly they got $40,000 of credit card debt. That wasn't really what you had in mind with your trust or with your funds that you were going to leave to them. The other thing that can happen, and in some of my anecdotes towards the end of this video, I'll talk about your home or a home that is purchased by one of your beneficiaries can be 100% protected in the event that that person goes through a divorce. And we'll talk about how that can work. Remember, when we set up these accounts for you, you choose the trustee. And if that trustee does not give you the answers that you want while you're vertical, you can change the trustee. With proper planning, you'll be able to take care of the people you love, the stuff you love, and you can plan now for the what ifs. So hear me out. Proper planning is not just about the end game. Proper planning is about all of the stuff that happens to lead up to that end game, which, as I'm sure we've all known, elderly people who retire at age 65, or in my case, I was able to retire at age 57, and I hopefully have 30 years left in me, 25 to 30 years. So proper planning includes all of that time in between before I get to that final end game. I want to talk about long-term care costs. They are huge. If you've not had experience with this, prepare for sticker shock right now. If you stay at home, I have some wonderful friends. One of them's 81 and the other one is 91, and they are able to stay in their home. They have a nurse's assistant come in five times a week, and they have a housekeeper come in to help them with cooking basic meals, doing the scrubbing of the toilets and keeping everything clean so that they are able to stay in place. It costs money, estimated between $500 a month for somebody like once a week, all the way up to $18,000 a month. You need a plan. You want something built into your plan that will provide for that. Assisted living, If you think apartments are expensive, brace yourself for the cost of assisted living. In the Northeast area, a good assisted living studio apartment, just like we had when we were in college, studio apartment, $5,500 a month in this area. If you go out to some of the outlying areas or upstate, it's going to come down to about 2,500. Still pretty expensive. Nursing home, again, in this tri-state area, it's going to run really about $14,000 a month. How in the world are you going to pay for that? You're probably thinking to yourself, Paula, I don't make $14,000 a month right now. How am I going to pay for that when I'm retired? Well, that's where Medicaid kicks in. So your pension that you've worked so hard for is not going to pay for that nursing home at $14,000 a month. You're going to need something like Medicaid to step in, protect your stuff, but let Medicaid pay the bills. You may have heard a lot of myths about Medicaid. You may have heard, well, if you go on Medicaid, they take your home. If you have a pension, you can't qualify for Medicaid. You may have heard you have to give everything away in order to protect it. You have to start suddenly spending and calling up your kids, calling up your niece and nephew and saying, guess what? You're getting my car today. Not true. If you give assets away, you have to wait 60 months to qualify. Well, that is still true, but we show you a way to have a graduated plan to kind of whittle down and also protect and spend in certain very smart ways so that you're investing in your home or in the things that you need and can whittle away on that 60 months. Medicaid is basically a very complex set of rules and exceptions to the rules, policies and exceptions to the policies. It's actually not a whole lot different from working in a school or in a school district. We show you your options and we show you how to get around them. The typical goals of an estate plan. Most people who come to me say, I want to be able to stay in control of my stuff. If you start talking to me, Paula, about a trust, what I hear is I have no control. Not true. I show you how to have control of your stuff, even though we're designating a trustee. Another big goal of most people, they don't want to become a burden to the people who they love and that love them. And they want to keep it simple. And I've talked about that. Most people, when they say, Paula, I just want a simple will, what they're saying is, I don't want to have to write a big check to a lawyer. Well, guess what? If you don't write a big check to a lawyer, your beloved child or your beloved spouse will be eventually paying that to the court or to accountants or what have you. Our goals are for you to understand the differences between documents and planning, understand all of your costs, and know your options. Now, how do we protect you from long-term care costs? I want you to meet well, first of all, I want to talk about Mary Smith. Mary Smith, Mary Smith's daughter visited a friend of mine in Lawyers with Purpose, and Mary Smith was panicked. She had consulted with the attorney who handled the closing on her house, dear friend of hers, and then that attorney said to her, well, Mary, if your mother isn't, Mary said, attorney who handled the closing on my house, my mother has gone into a nursing home and we don't know what to do. We just got this huge bill and all we can see is that we're going to have to spend. And the attorney who handled the closing on the house said, you're exactly right. You've got to sell the house. You've got to sell your mother's car. All of the cash that's in her account, that's going to go to the nursing home. All of the stocks and investments, that's going to go to the nursing home. Basically, everything that your mother has worked for all of her life is going to go to the nursing home. And until all of that is spent, Medicaid is not going to kick in and share any of that burden with you, even though she worked all of her life. She had about $450,000 in assets. So Mary called my friend from Lawyers with Purpose and said, is this really true? I mean, I really like this lawyer. He handled the closing on my house. And the Lawyers with Purpose lawyer was able to show her, I shouldn't have gone there yet, was able to show her how to protect everything. They were able to, because Mary Smith's, they were able to protect the family home and tuck away things in different parts of this trust that I've talked about. And from day one, Medicaid was able to pick up the bill for her mother's nursing home care. It was a very nice nursing home in upstate New York. $450,000 was able to stay in the family trust so that then Mary could have benefit of it, her siblings could have benefit of it, and their children could have benefit of it. Now, don't you think that Mary Smith's mother would much rather her $450,000 go to her children and her grandchildren than to the nursing home? That's a crisis planning that I was talking about. Suppose you're healthy right now. Suppose you're healthy, like Mr. and Mrs. Richards. They were age 75 when they went to see a friend of mine, pardon me. They said, you know what, we can't afford this 5-year look back plan, but then we've saved all of our lives and I guess we're doomed. I mean, if one of us goes into the nursing home and one of us stays at home, how's that going to work? Well, my friend from Lawyers with Purpose was able to take their $577,000, protect some of it right away from day one. Let me go to the next slide. From day one, immediately protect $449,000. That's a good nest egg, so that if the very next day Mrs. Richards had a stroke and had to go to the nursing home, $449,000 would be immediately protected. Mr. Richards would be able to stay in the family home. He would even be able to have housekeeping services come in and help him. What was at risk right away from the day that they made that plan at age 75 was $128,000. That if somebody needed care, that would be what they would have to pay out over time, making those monthly payments to the nursing home or to the in-home care. After 37 months, at $3,459 a month, there was a decline in the amount that would be vulnerable. Or if you want to look at it another way, there was an increase in the amount that was protected. So that not after 60 months, but that spend down really was 37 months, because that reached the point at which they were able to protect all $577,000. Now, Mr. and Mrs. Richards said to my friend, well, we're age 75, we're not going to live more than 5 years. Well, last time I heard, at age 85, they were still going to the diner every day. That was before COVID. I haven't heard how they're doing since COVID, but they were doing fine. And yet they had this plan in place so that if something happened, they were protected. Now, don't get in the weeds about the numbers. You might think, I don't have $577,000. Did you hear me, Paula? I am a teacher. Well, check your TDA. You might have more than you think. But the main point is we all have our own numbers. I just want you to get the story and get the message that we're going to take all of what you own, all of what you've got. We're going to be able to immediately protect about 80% of it. And then that additional 20% over time we're going to protect, so that if and when you would need long-term care, you would be able to qualify for the benefits that are out there and available for you. Other anecdotes. Now, I was a teacher. We all love teacher stories. Teachers love to get together and say, oh my goodness, did you hear about this kid? Or especially special ed teachers, right? We love to tell stories. I'll tell you a few stories. There was one couple, they left everything to each other. It was one of those reciprocal wills. Upon death, the surviving spouse, who had, always enjoyed the evening happy hour and cocktails, got into a drunk driving accident, unfortunately. So I mentioned that it's a drunk driving accident because some of you might be thinking, well, there's auto insurance. If my spouse gets into a car accident, he's not going to be sued because there's auto insurance. If it's a drunk driving accident, no go. The insurance is not going to kick in. Your spouse, who is grieving and therefore, went a little heavy on the alcohol, lost 80% of the nest egg that they had worked all their lives to save. That was not that person's intention when they left all of that money, or when they were working so hard during the life of their marriage to preserve that amount. It was very sad. Another story that's much happier. The surviving spouse they set up a trust. One spouse died, very sad. They had designated it so that their two children could be trustees. They first one child would be the trustee, and then if that child was not able, then they could designate the other child as the trustee. This trustee got a phone call from mom one day and mom said, you know what, I really want to replace the carpet in the apartment. It's old. It's been here forever. It's ugly. And the child who was the trustee said, well, gee, mom, I don't know. I kind of like that carpet, and you don't need that money. You don't need to get into the trust. Well, that was not the answer she wanted. So she called the other child and said, gee, this is what's going on. And the other child said, well, yeah, I'm so glad to hear you say that. I was over there the other day and thought, God, this carpet is so drab. And so the surviving spouse said, how would you like to be my new trustee? And they were able to make the change. So my point in telling you this story is you still have control of your funds. It's just you don't have the direct control. You're working through your trustees with certain provisions until you marry again. You would still be able to have that license to designate your trustee. If you don't like, it's kind of like kids. If you don't like the answer you got, go to the next person. There's that much freedom in it. Um, here's where that freedom gets kind of reined in. The surviving spouse got involved. I'm on my next story here. A much younger spendthrift friend who wanted to go to Las Vegas, wanted to go to Florida, wanted to lie around and not really, make it into the office every day. The trustees, who were the adult children, were able to provide a spending plan for the mom so that she could have fun with her new friend, but they could also wall off some of her assets so that if she became ill, they would still be able to take care of her, and so that they could preserve the original intent of the trust, which was that they would also have some benefit of the savings of the couple, of their parents through their lifetime. I could go on about other stories just like teachers can go on. So how do we do this? With the right trust, we could set up a testamentary trust, a living trust. There are tax trusts. I didn't really talk much about that. I talked about the estate tax. I've got some boxes here on the screen, and I've got this little red wagon. What's that all about? Think of a trust as a little red wagon. You remember those? You would haul it around with you. You could decide who got to haul it around if your friend wanted to play with it, but you wanted to put all your stuff in it and just kind of carry it with you. That's what we're going to do with your trust. And when we put all your stuff in your little red wagon, that is your trust, that's a very important step. Um, but I'm getting ahead of myself. Do you see this box that's sort of a U shape, RLT? That's what we get. Now, I'm a teacher. If I go to my union and they set up a trust for me, that's what we get. Now, it's open on the top. So what that does, it does accomplish the goal of avoiding probate. So upon my death, my revocable living trust makes it so that my heirs get to go through the 7 months of probate. However, you see how it's open at the top. The rule in trust planning is this: I must give up control of that which I want to protect. If I have control of it, like if I can reach into this RLT box and access those funds, then so too could American Express. So too could a lawsuit if I'm the one behind the wheel and have a drunk driving accident, God forbid. So too could a scam artist who calls me up one day and in a weak moment I say, well, of course I'll send you $45,000 to help the people of some faraway country. So that RLT is really the kind of trust that you would get through some of the subscription legal services that we as teachers have a right to. and that's part of our union benefit if you happen to be in the UFT. But you need to know that it's not going to give you the protection that you need. It will protect you from probate. I will grant you that. It just won't provide for your care along the way. You see that I've got IRR-AP, and there are several different kinds. The several different kinds speak to the fact that when we get together to plan your trust, we're going to have different protections in place, and each one will be custom fit. You see this one with the little spigot that can turn off and on? That's that trustee's role. There will be funds that you can access so that you can live. I mean, you've worked hard all your life. You're going to want to travel. You're going to want to be able to go to the casino if that's your thing. You're going to want to be able to go shopping. You're going to want to be able to maybe buy another place on the beach. That's that spigot that can turn off and turn on with the trustee's approval. There are other kinds of asset protection. That's what the AP stands for. Now I've got this IRR-tax. Some of you may have heard irrevocable trust and think, well, I don't really need that because I'm not going to be in a taxation situation. That really doesn't pop up for teachers. I just have it on the screen so that you can know not all irrevocable trusts are the same. There are many different varieties. So if you go to, if you're somebody who plays bridge, or if you have a big network of friends and you say, I was talking to this attorney about an irrevocable trust. What do you think? They might say, oh God, no, you'll lose control forever. No, not true. There are many, many different kinds of irrevocable trusts, but they're all designed to help protect your stuff. The revocable living trust protects your heirs. It avoids probate, but it doesn't protect your stuff, and it does not provide a plan for you while you're still on the planet. So how do you create your rule book? How do you create your custom designed irrevocable trust, either with the spigot or with the dashed line on the bottom? Well, we get together and we talk. We create your rules in your voice. We integrate your rules with where you are right now. Families are different. Every family has different configurations. You might have an adult child who has a tendency towards addictions. Well, you want to leave something to that child, but you don't want to spark some kind of relapse, or you don't want to fuel years and years of addiction to their detriment. Then the third step is that we want to maintain your rules. So one fault of estate planners is that they don't follow up with their clients. It's very, very important that by the time you die, that your will isn't 20 years old and hasn't been looked at in those 20 years, because a lot of stuff could have changed. We want to have a maintenance plan so that each and every year we're looking at the new policies for Medicaid, we're looking at the new tax laws, and we're looking at your life circumstances and your family's life circumstances to make sure each and every year that your plan is still a plan that is relevant to your family system. Without all three, your rules really won't work. So we talked about typical trusts. We don't want to have just documents. Most of the legal services plans still, like that revocable living trust, would still have the 2-doctor requirement. So that is sort of the default. And then what we want to do is custom design a plan. You could have it so that 2 of your best friends would say, you know what, I talked to Paula and she couldn't even remember what year it was. Well, guess what? That's kind of me right now. But and my point is, since COVID, I can't remember what year it is. But my point is, the statutory requirement of the 2-doctor incompetency with the hearing I talked about earlier, that is a statutory requirement unless there is another plan written in. So your plan might be that your adult children can determine when you are incompetent or when you need to start giving up some of those powers of attorney and some of those the access to account. Or you might want your 2 best friends who have been with you since college to be the people that would determine that. It's your plan. We write it in. Just know that the legal services plans would default to that 2-doctor competency. Let's see. Having a rule book is the first step. There's a term, integration. It's different from what we talk about integration in other contexts. I talked about the little red wagon. We want to put your stuff into the little red wagon. Many people, again, this is where it falls upon the attorney to do the follow up to make sure that the client did their homework. Kind of like teachers, I have to follow up and make sure the homework has been done, or else step in and help the client retitle everything. So your house would not be owned by you directly. Your house would be owned by the trust of whatever your name is, Paula Collins. My stock account would not be owned by me. It would be owned by the irrevocable trust of Paula Collins. All of those boxes put in the wagon are what make your trust actually work. Anything that is outside of that little red wagon that did not get integrated into the trust would still have to go through probate, would still have to go through that 7-month process that is very expensive. Um, Again, I'll talk about joint accounts or beneficiary designations. I'm always really happy when I pull up different accounts and see that I have a beneficiary designation. I still want those integrated into my plan because they will avoid probate, but I still need to make some type of consideration for them to integrate them, because I want to make sure that they get the protection and that they're included in the overarching plan that we revisit every single year. Things change, you have to maintain the plan. And some people will just wait till something happens. They'll sign their documents, we'll get them notarized. I got my daughter designated as a notary, so that's kind of cool. And we'll get them all notarized and they'll go off, and I may not hear from them for a while, and I need to follow up and check in with them, or the client needs to have a regular appointment to come back and check in. Remember, your documents and your plan is only as good as it is at that moment. If you made your plan 10 years ago, you really need to revisit it. So I hope that we have in this workshop gotten at least the discussion in your mind as to whether you're all set. I hope that you've come to an understanding of what it is to protect you, your stuff, and the people that you love. And I hope that maybe I've been able to show you some of the things that are missing, and that perhaps I'll hear from you and we can talk about a plan that suits you, suits your family, and suits your life circumstances. Thank you very much. Thanks for listening. Oh, that's all the stuff we covered. And here's my contact information. Have a great day.